Okay, welcome everyone. Thank you for coming today and joining us. My name is Sally Pinto, and you are here for the special planning estate planning webinar with us. I have Sarah Myers with us, who's an Esquire with partner in Inia Scanlon and Sirignano. We also have Roberta Goodman, who's a lawyer with the Pace Women's Justice Center, and Isaac Cohen, who's a financial advisor with Bedrock Wealth Strategies, and they'll be introducing themselves in a couple of minutes. Again, welcome. I'm with WWA, which is the Westchester Women's Agenda, and our group is the Female Economic Empowerment Group. The Westchester Women's Agenda is the leading advocacy group working to improve the lives of women in Westchester County by advancing racial, economic, and social equity and justice for all. Please visit our website, which will be placed in the chat, and learn more about us. We have nonprofits and individuals as members, so please come join us in a meeting, see what we're all about. Join the committees. As I said, the Female Economic Empowerment Group is one of those committees. There's a lot of committees. I wish I could be part of all of them, but I can't be, but please do come and learn more about us and learn more about our committee as well. Just wanted to acknowledge some groups who are made this happen and our sponsors as well. The Westchester Library System, who has a watch group going on. Thank you. The Yonkers Public Library Crestwood branch with Z Baird, who's the branch manager there. And we have one of our co-chairs, Juliet Armstrong, over there. So I'd like to acknowledge her there and her help there. We also have West Hab staff and the National Council of Negro Women. And we also have Lisa Boileau is with the Westchester Library System up there on the 4th floor in 570 Taxter, and she's also a co-chair. Like I said, my name is Sally Pinto. I'm with Primerica, I'm financial representative, but I will be your MC for the event. Just to remind everyone that this webinar is a free community service and for knowledge sharing, and it is not a sales or promotional event. The speakers here are donating their time today. Also, a reminder that for those online, we want to remind you that the lawyers on our
Sally,
you just muted yourself.
Oh wow, how did I do that? Okay. So what was the last thing everybody heard?
That we're donating our time.
Okay, wonderful. Okay, donating the time. And all right, so if you done which one? Okay, donating their time. All right, so I'd like them to introduce themselves, and then I'll do a little caveat because we do have Sarah and Roberta are New York State lawyers. So first, to invite themselves to introduce herself is Roberta Goodman from the Pace Women's Justice Center. Hi, Roberta.
Hi, Sally. Thank you. Good afternoon, everyone. I am Roberta Goodman. I'm a senior staff attorney at the Pace Women's Justice Center, specifically in the Elder Justice Unit. The Pace Women's Justice Center is located on the campus of the Elizabeth Howard Law School, Pace, formerly just Pace University in White Plains. And we also have satellite offices in the courts, in the White Plains Family Court, the New Rochelle Family Court, and the Yonkers Family Court. And I appreciate the opportunity to come and present today with Sarah and Isaac, and thank you to the Westchester Women's Agenda.
Thank you, Roberta. Sarah Myers, from a partner at Inia Scanlon and Sirignano. Thank you, Sarah.
You're welcome. First, Roberta, thank you for thanking the Westchester Women's Agenda and the Female Economic Empowerment Group. So the rest of Isaac and I did not have to. So Sally, thank you for having us. So my name's Sarah Myers. I'm an attorney with the law firm of Inia Scanlon and Sirignano, and I practice in the area of elder law and estate planning and focusing on Medicaid planning and protecting assets from the cost of long-term care. And thank you for inviting me today.
Thank you, Sarah. And finally, Isaac Cohen.
Hi, everyone. My name is Isaac Cohen. I'm a financial planner, CEO and founder of Bedrock Wealth Strategies. We are a firm that focuses on helping business owners, entrepreneurs, and high net worth individuals maximize their planning opportunities. We focus in on estate planning, wealth management, legacy planning, as well as helping business owners prepare and get through the sale of their business. And thank you very much for including me here.
Thank you, Isaac, Sarah, and Roberta. Again, for those online, we want to remind you that the lawyers on today's panel practice in New York State. So their comments are specific to New York. And we would encourage everyone to follow up with an attorney to help build your own plans. So let's make sure everyone knew that. Okay, first question is for Sarah. Sarah, what is estate planning and why is it important? And who needs to do it? Is it just for rich people?
Okay, so I'm going to answer go backwards. Everybody, once they turn 18, should be doing some form of estate planning. Again, I don't think estate planning by an 18-year-old should encompass a will or a trust or Medicaid planning. But once a person turns 18, he, she, or they should have a power of attorney and a healthcare proxy to designate somebody to make financial and/or medical decisions for them. But what is estate planning? Estate planning is having a will and other documents such as a trust or advance directives, which Roberta will talk about in a couple of minutes. So upon passing, can designate who should receive, who should inherit from them. And it's also planning in terms of protecting assets from the cost of long-term care, possibly estate tax planning. So you have control, again, of what happens to your assets upon your passing. And also control over, if you become incapacitated during your lifetime, who's going to make financial and medical decisions for you. Wealthy people can become incapacitated. Middle-class people can become incapacitated. Low economic individuals can become incapacitated. You know, dementia, Parkinson's, neurological issues don't affect only one socioeconomic class. It's important for everybody to, in advance of, God forbid, an incapacity, to have documents designating whom they wish to handle their affairs in lifetime, and then where their assets should go upon death. And, you know, rich can be a subjective term. I've worked my whole life. Whatever money I have is mine, no matter if it's 100,000 or 1 million or 2 million, I should still be able to control who's going to inherit those funds and how.
That makes a lot of sense. And just a tip for everyone who's online, just have a pen and paper handy and write down these really great tidbits because it does. I have a 21-year-old, so she should have a power of attorney. So that's a good point for me to put down. So talk to us more specifically about the will. What does it do and how does it work?
Okay, so a will is a document that states who you are. Right, it's on a piece of paper. So the will is as good as the paper is until you pass, and it's admitted to what's called probate, which happens here in the Surrogates Court of Westchester County. So the will states who I am, who I want to inherit my stuff, my furniture, my jewelry, my artwork upon my passing, known as my tangible personal property, who then is going to inherit and receive my money, my cash, right? My brokerage account, my checking account, my house, and then who's going to be the fiduciary, who's going to be in charge of my estate to pay the bills, and then to also distribute the estate assets to the beneficiaries listed in my will. It's important to note, and I know we'll talk about this a little bit later, the assets that pass through a person's will are only those that are in, the decedent's, the person's name alone. So if I own a house jointly with my spouse, I pass first. The house, by operation of law, goes to my husband. That does not pass through my will. What passes through the will are only those assets that are in your name alone, that aren't joint with somebody, that don't have named beneficiaries or in trust for or payable on death designations. And again, the will, you get to then control where your assets go upon your passing.
And those are very good points. And we see in some commercials on TV, create your own will. How does someone go about creating one?
Okay, so what I would recommend is not handwriting a will and signing it. A will should be done by an attorney. And who should follow all the what are called the proper procedures for executing a will and having the proper language in a will. We're in New York State. A will needs to be witnessed by two individuals who are not related, who are not going to be beneficiaries under the will. It can't be signed by someone for you. And again, and have to follow certain parts of the statute in terms of what's called proper execution. But I do recommend, and this is not self-serving, this is for all individuals in New York, should use an attorney. And there are pro bono attorneys, for example, various legal aid offices for individuals who are low income, and then all different priced firms depending on the will, that's the work to be done. But a person should use an attorney when having a will done.
And when does it become contestable? You had already mentioned that, the surviving spouse doesn't go through the will if they own real estate jointly. But when does the will become contestable?
Okay, so I think that's two different statements there. So let's just backtrack. So what we were saying is if there's an asset that's owned, I'm the one who's passed away and I own a house jointly with my husband. Upon my death, that house doesn't pass through the will. They can't go to the kids if the kids are the beneficiaries under my will. That passes to the joint owner of the house or the joint owner of a bank account or a brokerage account. I think your next question is who can challenge a will? Who can contest the will? So anybody can do anything they want to do. It depends on whether or not they have the legal standing to do it. So for example, Sally, you pass away, I can go to court and say, hey, Sally promised that she would leave me everything, but I'm not what's called a distributee. We don't have really any relationship. Just because you said you were going to leave me money, it doesn't mean you have to. And that's not what's called enough standing for me to get into court to prove that, that I'm entitled to receive funds under your will. Anybody can contest a will, but again, the question is, can they get into the court? Do they have standing, the ability to challenge the will? A lot of times we see will challenges where Roberta, Isaac, and I, the three of us are siblings, and we're not, I'm just using that as an example. Our mother passes and leaves everything to me. Roberta and Isaac can say, Sarah was unduly influencing mom. Sarah isolated mom. Sarah pushed mom away. In fact, mom used Sarah's lawyer, didn't even use her longstanding attorney of 50 years. And, this was done under duress and undue influence. Then, Isaac and Roberta can go to court and say, we object to the will being admitted to probate, and we are going to file objections because of undue influence or lack of capacity. And again, to state again, Isaac, Roberta, and I are not siblings. We are not engaged in any estate litigation against each other at this time.
Wonderful, wonderful. I know there's some great questions coming through the chat. We'll deal with the questions at the end of the webinar, but keep the questions coming. They're wonderful. So I'm not sure if this was answered, but I want to make it just clarify it for the audience. What takes precedence, the rights and entitlements of a surviving spouse or the will or something else?
Again, those are sort of parallel questions. What happens is this: when a person has a will and has a spouse, and the spouse is still alive, a spouse is entitled to the 1/3 right of what's called 1/3 right of election. So my husband and I are married. We have 3 children. I leave everything to our 3 daughters, nothing to my husband. He can say, hey, I'm asserting my right of election. I'm asserting that I'm entitled to 1/3 of Sarah's estate, when she passes. So that's the right of election. If I pass away without a will, the courts look to a statute of what's called intestacy, dying without a will. And when you die without a will, leaving a spouse and children, the spouse gets the first $50,000 and then 50%, and the kids get the other 50%. So when there is a will, the spouse, even if you leave the spouse nothing, is entitled to their 1/3 right of election if they choose to take it. Many couples don't leave anything to the other spouse for Medicaid planning purposes or estate tax planning purposes. So a lot of times it's done in concert with the spouses, with the understanding that the surviving spouse won't take the right of election, but it could have been a bad marriage. And I'm saying, I don't care about you, honey. I'm leaving everything to the kids. My husband can assert upon my passing that 1/3 right of election.
Wonderful. Good to know. Roberta, please explain the difference between an executor, a guardian, trustee, a financial agent, healthcare agent, and are the best practices about who to choose or not to choose for those roles?
Okay, so the category is fiduciary. All of these titles are different roles depending upon the document where this fiduciary is named. So we'll start with executor. An executor is someone who is named in someone's will to identify and collect assets, identify debts, determine if these debts are valid, if they are valid, to pay them, to determine where are the beneficiaries, to notice them, to perhaps hire a tax professional if an income tax return or an estate tax return needs to be filed, depending upon the size of the estate. The executor would also engage an attorney to help prepare the probate petition if there are assets that are going to pass through probate, because you can have a beautiful will, you can name all these fiduciaries, and then every asset that's owned by the decedent has a designated beneficiary or a joint owner. So the will may become superfluous. You know, every now and then there's one asset that that slipped through the cracks, or there's a reimbursement or a refund from the cable company, for example. And when the person whose name the bill was in passes, in order to collect that refund, you need legal status. And so you might have to file what's known as an administration proceeding, a small estate. Even though you have a will, you're saying to the court, this estate is under $50,000. I really would like to get the $500 so it doesn't go into unclaimed funds that I'm entitled to from medical reimbursement. So an executor is a fiduciary. An executor can get paid or not paid under a will. It's called commissions, and it's a statutory amount depending upon the size of the estate. Most people, if they are fortunate to have a trusted individual who's responsible, in addition to being trusted, can name an executor and an alternate. Some people like to name co-executors. You know, perhaps they have no spouse, but they have 2 children, and they don't want to hurt the feelings of one of the children by designating them as the sole executor. So they might name them as co-executors. And the next fiduciary role would be a trustee. You can have a trustee who is named in a trust under a will. Depending upon how the will is drafted, it might contain a trust. It's called a testamentary trust. And that trust needs to be administered by somebody, and that person would be the trustee. The executor doesn't manage or have a role in the trust. The executor would only, let's just say, collaborate with the trustee to see if there's a financial advisor perhaps necessary to help manage the funds that are in the trust so that they don't get depleted and they're invested appropriately. There can also be a trustee from a standalone trust. That's a trust that's created during a person's lifetime, because the testamentary trust, if it is triggered at all, is not triggered until a person dies and a will is submitted to probate. But you could have what they call an inter vivos trust. That means created during lifetime. And that could be revocable trust, or it could be a trust that's not revocable, irrevocable. So what is a revocable trust? A revocable trust is really an alter ego of the person who funded the trust. It carries their social security number. And when you have a New York resident who may own property outside of New York State, it's advisable for them to put that property in a revocable trust so that they avoid what's known as an ancillary probate proceeding in New York. A revocable trust provided it has the appropriate language, can be amended at any time until the creator of the trust either loses capacity or dies. Once that person dies, obviously you can't amend it. An irrevocable trust can be is also created during lifetime, and it's created for many different reasons. A significant part of Sarah's practice is the creation of trusts that are no longer revocable. And those trusts are created to provide some level of asset protection. I'm going to let Sarah address that later. I'm just trying to identify the roles of all of these fiduciaries and in what kinds of documents give these fiduciaries the authority to act. I just want to go back for a moment to the will. If you don't have someone to serve as your executor, you don't have a family member, you don't have a trusted friend, your lawyer said, no, I don't want to have that responsibility, there is a statutory individual, it's a firm, it's called the public administrator. And the public administrator is appointed by the surrogates court, and they would serve as the executor under a will of someone who didn't have an individual to name. Okay, so a guardian. A guardian is a court-appointed individual, could be a society like FISI, the Family Service Society of Yonkers, or it could be a lawyer, it could be a family member, but it's as a result of a court proceeding. And it's a proceeding because the individual who needs assistance is unable to manage their affairs. Now, there are two types of guardians. One is a voluntary guardian, where let's just say I realize life is getting too complicated and I can no longer manage my financial affairs. I still have the capacity to know that I'm having challenges, and I don't have anyone. I have no family. I have no friends. I've outlived everybody. And I want to make sure that I'm not going to be exploited. So I'm going to ask the court, I'm a person in need of a guardian, and that's called a voluntary guardianship. And I might be able to participate with the court-appointed guardian to manage my financial affairs. On the other hand, if I lose capacity and it's clear that I'm at substantial risk of harm, then what happens is someone, maybe it's a long-term care facility, maybe it's the County of Westchester, or maybe it's a concerned friend or family member, will file with the court a petition to have you declared incapacitated. It can only be done in a court proceeding, and you do have the right to attend that proceeding. And if you are determined to be incapacitated, then the court appoints a guardian to manage your affairs. And it could be your financial affairs, or it could be your personal affairs, your health. One way to avoid risking a guardianship is to do a financial durable power of attorney. And that is a document that absolutely should be done with the assistance of an attorney. It's governed by New York state law under the general obligations law. And under the durable power of attorney, it doesn't lose its effect if you lose capacity, which is either temporary or, can be permanent. It does not survive your death. Once you die, the power of attorney is no longer a valid document. And you can name a single agent, you can name multiple agents, you can have multiple agents act independently, or the agents can act, they can act together or they can act independently. If you are concerned about, again, we'll go to multiple children and, they live all over the country, and it's going to become somewhat challenging to have them work together. So you're only going to name one of them as the primary and the other one as the successor or the alternate. But you don't want to hurt the feelings of the third one. So you might appoint them to be a monitor so that they have the legal right to say, okay, on a quarterly basis, can you just tell me, what money's coming in and what bills are you paying for our parents? Or on the other hand, if you don't have a family member and you're having a a friend who is a good friend, but not someone you've known very long, but they agreed to be your agent, you might want to appoint another person as the monitor to make sure that whatever transactions the appointed agent is doing, that they're doing it appropriately and they're not misusing their funds. Healthcare agent. Okay. Healthcare agent, I think, is one of the most important roles that anyone can have, because this is an individual who is going to make medical decisions for you if you are unable to communicate those decisions because you've lost capacity. And the advanced health directives, the healthcare proxy and the living will. So the healthcare proxy is only triggered when you have been determined to lose capacity, and that determination is made by a physician. So some people, you know, if they've called 911 and the emergency medical technicians show up, and then you say, but wait, my parent has a healthcare proxy and they didn't want extraordinary measures. EMT cannot determine lack of capacity of that person. And so the only way that they can not do anything is if there's a pink form that's called a MOLST, a medical order for life-sustaining treatment, or POLST, physician ordered for life-sustaining treatment. If those documents are in the apartment, in the home, then EMT must respect them and not initiate any life-saving measures. The healthcare proxy designates a trusted person, and you can only name one at a time to make your medical decisions for you. And the reason why it's only one person at a time is it would be frightfully confusing for the healthcare practitioners. They can't play Solomon. They can't decide whose decision they're going to take or not. It would go to an ethics committee at that point. But you can name alternates, and you can personalize your healthcare document to say, I would like my designated agents to confer with one another before, and with my treating physicians and healthcare providers before a decision is made. In the absence of a healthcare advancce directive, if you're in a group home, a facility, or a hospital, there is a statute that it's called the Family Healthcare Decision Act, which dictates the order of priority where who has decision-making authority over your healthcare. Then you have a living will. A living will is the document that expresses what medical care you want or don't want. And let's just say you don't have a person to be your healthcare agent. You can, in this living will document, state, if my quality of life is going to be so dramatically different than the one I enjoyed before this event happened, et cetera, I do not want. And so your healthcare providers have some expression, they have some evidence of what kind of treatment you would want or not want. I think there's one other role that I want to mention, and because it leads to another document, so I'm kind of combining documents with roles. It's called a HIPAA release. So that's the Health Insurance Privacy Accountability Act. What does that mean? It means it's a federal law, and your health information, your medical information, is confidential, and no one has access to it unless you waive that right. Whenever you go into a physician's office, a healthcare provider, hospital, you're always asked to sign a HIPAA waiver. And that HIPAA waiver is for the insurance companies, because your providers want to get paid. In order for them to get paid, they have to provide proof that they provided medical care to you and what the care was. But let's say you are currently receiving care. You have total capacity, but the physician's visit that you just had, your medication regimen was completely changed. And now you have to take different doses of the pills at different times of the day. And you were thrown by that information, and you walk out of the office because maybe you only had, 2 minutes of a conversation and your head is, just swimming. And you say, I don't have a clue. what they just told me I need to do. So you ask your person that you named in your HIPAA waiver, could be a spouse, could be a friend, could be any family member, and that person has the legal authority to connect with the healthcare provider's office to say, my so-and-so has given me permission to receive confidential medical information. Can you please review for me what you told him or her or them? And it is a document that then the healthcare provider knows that they have the legal permission to release the information. So I think have covered the ancillary documents and the roles of the different fiduciaries in acting under each of them.
And these are the post of the most seems one of the most important to have handy when an EMT does come through the door. Obviously,
Well,
some people put it on there.
Yeah, I mean, typically you don't have that document unless you have an advanced diagnosis of a life-shortening issue, or perhaps you've reached a certain age and you have enjoyed a really good life and you just don't want any invasive treatment, and you've had this conversation with your doctor and your physician has agreed that it is appropriate based on your conversation and all of your medical history and so forth, that it would be okay not to administer life-saving treatment.
And you went over quite a few documents. Any other documents that we'd be missing other than the financial durable power of attorney, the will, that are important for us to have as part of our estate planning?
Well, we talked about a revocable trust or a trust that's not revocable. We've talked about an advanced health directive and the HIPAA waiver. I think that covers all of the legal documents. And to Sarah's earliest point, if you are 18, you should definitely have an advanced health directive, because your parents have no right to your medical information. So it's really an important document, and it doesn't have to be notarized. It just needs to be witnessed by two people who are not your treating physicians or healthcare providers. And it's two witnesses over the age of 18. Now, a durable financial power of attorney is a good thing to have if you have someone over the age of 18 who may be living out of town. Maybe you have a college student, and the college student, you're on a joint bank account, or you're on some account with a student. You need to manage something for them while they are busy studying and hopefully going to be launched at some point soon. So that's a good document to have for them.
Sarah, so what do we do with all of these documents after we sign them?
So what we usually suggest, well, there are two options. You've done your estate planning with your attorney. The question is, after the signing, who keeps the documents? Does your attorney keep the documents, or do you take them home with you? So first, I'll start with the electronic copies. It's very important to have electronic copies of your documents. That way somebody knows where they are. I recommend giving a copy of your healthcare proxy to each of your doctors, right? So they have it on file there, so they know who they have permission to speak to if you're unable to make medical decisions for you. I think in somewhere in your house where somebody knows, you should have copies of all the documents. Someone should know where your power of attorney is in case, God forbid, you become incapacitated. Someone should also just know who part of that is, who's your attorney, who's your accountant, who's your financial advisor, who are your doctors. This should all be listed somewhere, and somebody should know where it is. When it comes to the original documents, and I'll just so you know, on my dad's healthcare proxy, as well as my 3 daughters over 18, I'm their healthcare proxies too. God forbid I should have to use them. I actually have copies of them, and they're all saved on my phone, because you just never know. God forbid there's a car accident or an emergency. I know where they all are, and I can always run to a hospital and demonstrate that I am the healthcare proxy. in terms of the originals, most attorneys' offices will hold original documents for you. Most attorneys' offices should have a fireproof, waterproof safe. The problem is if an individual takes his or her will home, it's stored in a basement, the basement floods. It's stored in the attic has a leak, or God forbid, a fire. What happens if your original document is destroyed by mistake, not on purpose? Or you move and you just, everyone's done this. They just go through papers and they throw them out, and you by mistake threw out your original documents. So if you are going to keep your original documents, do not keep them in a basement or an attic. Mark them as important original documents. Also, for an original will, if you unstaple a will and then you seek to have that will admitted to probate, you have to file an affidavit with that will of unstapling to explain to the court why the will was unstapled, right? And it could be because I didn't know I couldn't unstaple it and I wanted to scan it to my attorney. Because again, we don't want, Isaac, Roberta, my mom, right? We did a will leaving everything to the three of us. I unstapled it, left everything to me, and put it all back together, right? So we don't want someone taking a page out and putting a new page in, but it is a personal decision. Do you hold the originals or do you give it to your attorney to hold? And there's no right or wrong answer. I can say from our practice, I think probably 90 to 99% of our clients have us keep their original documents.
Remember the unstapling. That was one thing that my lawyer did say. It was, okay, I won't unstaple. That's all right. Don't worry about it. Isaac, finally we get to you. Everything's good. Sarah and Roberta have offered great information. We know there are wonderful questions in the chat, but we're going to now go to the financial advisor. What is the role and main objectives of the financial advisor in estate planning process, and how does it differ from what Sarah and Roberta would do?
That's a great question. So the way I see it, and I do see it perhaps a little different than many other advisors. I believe that the role of a financial advisor, financial planner, is to coordinate the financial planning team, which includes attorneys, accountants, etc. But every financial advisor's practice is different. So the most important thing from my perspective is that you interview your financial advisor or the advisor that you're thinking of working with to understand what they believe their relationship to that process should be. Some advisors like myself are very involved in the financial planning process and come up with the financial planning model that then leads to the estate planning documents being created and all of the work that comes as a result of that. Other financial advisors are more inclined to be product placing. And so what they might do is offer you financial products like insurance products or wealth management tools like investments to reach your goals, but they're not necessarily going to be the ones proactively making recommendations on how to improve your financial plan. So what I would suggest is that you do a great job of interviewing those individuals and then decide who is going to take that leadership role, or whether or not you're comfortable taking that leadership role on yourself.
So, what are some of the hallmarks of a wait, I skipped the question. How do you ensure that the financial planning and legal planning come together to achieve a consistent and not contradictory result? You said you funnel the information together. How do you make sure it keeps going smoothly?
It's a great question. So when I was in the military, I found that leadership, accountability, and coordination were really, really important. I would tell you that it's the same thing in the financial planning process, especially when you're talking about someone's essentially their entire estate. So whether you're talking about a very uncomplicated estate or a very complex estate, all of those hallmarks are quite important to have in place, because you are going to need someone to coordinate all of your experts, all of your team. You are going to need to have all of your documents drafted, and at the very same time, or nearly at the same time, there may need to be a change in ownership, or there may need to be new products purchased, like life insurance, to put into things like trusts. So depending on the complexity of your financial plan, and depending on the complexity of your estate, would dictate what financial products, what financial solutions need to be added or taken away. But there should be someone coordinating all of that. Otherwise, it unfortunately falls on the client, and what ends up happening is things can get missed. I'll give you a great example. So I was working with a client who, prior to meeting me, had already done a very sophisticated estate plan. But unfortunately, because there was no one coordinating that process, they took on the role of making the changes to their life insurance. Who's the beneficiary? They were supposed to go back and change all of their 401k beneficiaries as well, not just their current one, but their old one as well. And I'll tell you, this particular client had almost $1 million in her old 401k. But when we did the review, we found that the beneficiary designation was her ex-husband. I can tell you that her husband was not happy with that. So little things like that can fall through the cracks. And so it's really quite important to make sure that everyone is working together.
Just a tip, review your beneficiaries every 6 to 1 year. And anytime there's a life change, review it. Very important. What are some of the I think I already went to. How often should one review? I think I answered your question. How often should one review and update their estate plans, the legal documents, and also the financial plan, and how? Isaac and Sarah. Isaac, you can start.
Oh, sure. So I typically recommend that a financial plan be revised every year. And the reason for that is that life changes quite often. And whether it's a change in circumstance, a change in family dynamics, or a change in your business or in your health, all of these changes should be reflected in your financial plan. I like to give examples. So Sally, one example that I'll give you is I had a client, unfortunately, recently be diagnosed with both Alzheimer's and dementia. And this is only about 6 months after we updated his financial plan. Well, when I received that phone call, we didn't even wait the year. We updated everything, went through all beneficiary designations, realized that there were a slew of things that needed to be updated and changed. Children needed to be communicated with, and everyone needed to be coordinated once again in order to make sure that his financial plan was able to come to fruition in the way that he chose. So I guess to answer your question, I don't know that there's a 6-month or 1 year timeline on the updating of legal documents. What I would say is if there's a life change, and I'll let Sarah answer this one, but correct me if I'm wrong, Sarah, if there's a life change or if there's a change in legal language that requires a change in those documents, then that would be the time for that. But otherwise, on the financial planning side, it's really more about what's happened since the last time we've talked, and does it warrant making a change?
Sarah, what's your view on the legal side of it?
So I actually liked Isaac's example, not that a client of his has Alzheimer's and dementia, but more, I very much appreciate Isaac saying they were very proactive in looking at the plan at the eyes of now somebody who's older with a significant, going to have cognitive decline. Because if that client had come to me as well in terms of the legal aspect, we would have looked at all of his estate planning documents, made sure his power of attorney had broad gifting. We would have looked at doing Medicaid planning if they didn't have enough sufficient funds to pay for home care and or nursing home care. And again, reviewed, all of the planning, making sure the individuals named in his will are still what he wants to be the beneficiaries. But even more importantly, going to what Roberta was talking about earlier, really taking a hard look at the power of attorney, healthcare proxy, and living will, because more likely than not, he would, before passing, he would lose capacity to make financial and medical decisions to really make sure that individuals chosen at that point, the agents and the healthcare proxy and power of attorney, are the ones he wants to make those financial and medical decisions for him. We talk about estate.
Yeah. Sorry, Sarah. No. Please. I was just going to suggest something as you're speaking, Sarah. One thing that comes to mind is how integral it is that we all work together on the planning team. Because it's as wonderful as it can be to have a great wealth manager, financial advisor, a great attorney, that collaborative communication is so important, because there's a lot of knowledge that we can share, and there might be conversations that have been had with your advisor that haven't been had with your attorney, and vice versa. And so my one recommendation for everyone today is that if you can get them all in the same room or in the same Zoom like we are today, that would probably be the most valuable thing that you can do in creating a really unified plan and making sure that everything is up to snuff. Sorry for interrupting that, Sarah.
No, but I actually like the holistic collaborative approach. I actually just met with a new client of mine with her financial advisor, because we did planning years ago for mom. She was the power of attorney, the healthcare proxy and whatnot. But mom now has significant, sold the house, is in private pay assisted living. And we had to look at with the financial advisor, is there enough money to pay for care? And should we be doing Medicaid planning now for nursing home care to get outside the 5-year look back for nursing home care? And I was going to say also, your documents are as good as they are, but if you don't retitle assets to them, so, Isaac and I can share a client. I've done this great revocable trust for the client to have, all his brokerage accounts retitled to, and working to make sure they're beneficiaries on the ones that are not part of the trust. But then if the client doesn't say, hey, Isaac, I just met with Sarah, we did all these great documents, right? A client can have a trust, but it doesn't mean anything if there's nothing titled to it, if the trust doesn't own anything. So again, yes, I like very much the collaborative holistic approach, because it just benefits the client more. But Sally, just stepping a little further back in terms of how often to do estate planning, we really talk about sort of estate planning in your 30s, 50s, 70s, 80s, 90s, right? Because the needs of a 30-year-old and the estate planning a 30-year-old is going to do, it looks very different from a 50-year-old, which looks different from a 70 or 80-year-old, right? When you're in your 30s, perhaps you have a family, perhaps you have a spouse. You want to do a will because, God forbid, something happens to you and your spouse, and kids are under 18, who are you going to appoint as their guardian? Or having a trust for the funds, so when they turn 18, they don't get all this money at that period of time. Please God, by the time you're in your 50s, if you have children, those kids are going to have launched, or you might have a child with special needs. So your planning is going to look different to address the children who have launched, as well as addressing a child with special needs who's come of age, who's no longer 18, 21. Then in your 70s, 80s, if you have a grandchild with special needs, or one child has done much better than the other kids, or your assets are minimum, but you have a lot of income, do we need to start putting a house into a Medicaid trust? So the reason, and sort of going full circle, one of the other reasons why I think it's important when our kids turn 18 to do a power of attorney and healthcare proxy, aside from the fact that they should be doing it, is it starts the conversation about legal literacy, right? I have clients who are in their 80s who've never done an estate plan. I have peers of mine who have done their estate plans, and why didn't they do it until they were in their 50s? Because they couldn't decide who was going to be the guardian for their kids. Right? So the same way we need financial literacy, right? In high school, you learn how to balance a checkbook. You learn that if you can't charge more on the credit card than you can pay, right? Like part of that is, destigmatizing. And I appreciate we have about 50 participants here, right? It's so important to destigmatize estate planning. Some people think, right, it's the old wives' tale, I'm going to sign my will Tuesday and I'm going to die on Wednesday. It's not that at all. It's not, it doesn't cause something bad to happen. I see it actually as control and taking responsibility and trying to, again, why are we all here? We're trying to destigmatize estate planning and financial planning. These are just part of that adulting we should not be afraid of, but really embrace.
Those are all good points, especially the earlier that they start, especially since we've mentioned that 18. It seems to be a key year for a lot of the documents. We can't even get an 18-year-old's grades, never mind, right? It's the first time when I heard that. No, you can't have access to their grades in college. Think about it. So if that's just grades in college, so think about if something happens to them. So now that we've gone through the pieces of estate planning, take us through to what acts, Sarah, to what actually happens legally when a person passes away. Does everything go through probate automatically, and what is the process? And I've heard some really horror stories as well on that.
Okay, so first thing, if you don't have, people think if you don't have a will, the government's going to take your money when you die. You might owe taxes, estate taxes, but the government doesn't take your money when you die. So we talked about this earlier in terms of doing when we do a will. So the assets that pass through the will are only in the decedent, the person's died. We'll use me, I passed. What passes through my will? Only those assets that are in my name alone. They're not titled to a trust. They're not owned jointly with someone else. They don't have in your name beneficiaries. So let's go through some assets. A life insurance policy. If I have a life insurance policy, which has named beneficiaries who are alive when I pass, that the proceeds from the life insurance policy doesn't pass through my will. It goes to the named beneficiaries. So it goes back to Isaac's point earlier in terms of it's really good to do that checkup every year or so, because I have a life insurance policy. My husband and I bought them when everybody was little. He's the beneficiary of mine. I'm the beneficiary of his. I've passed away. He's already passed. There's no secondary beneficiary. So make sure there's secondary beneficiaries, right? Or if the person, the primary has passed and you don't have a secondary, to add new beneficiaries then. Same with retirement accounts, your 401k, IRA, 403b, qualified annuities. Make sure all of those have named beneficiaries. And if there's a spouse, it's usually the spouse. And then also have secondary because, right, spouses leave everything to each other. More often than not, one spouse will pass before the other. So have secondary beneficiaries. So anything that a brokerage account can have named beneficiaries on the account as well, or be titled to a trust. So what passes through your will? Only those assets in your name alone, not in a trust, not joint with somebody, not payable on death, transfer on death, in trust for, just name is Sarah Myers, that's it. That's the asset that passes through the will or through estate administration. Was there more to that question, Sally?
No, that was it. That was part of the question, but if you'd like to add to it,
No, I think so. Again, just so if people know, if you don't have a will, as we talked about earlier, you do something called an estate administration through the surrogates court. So again, there will be someone with legal authority to be able to act. Also, it's important to get, just comment like death certificates. Usually you can obtain those from the funeral parlor. And it's also important to note the month a person dies, Social Security takes the Social Security payment back. So if you die in January, your January payment, Social Security gets that back. You're not entitled to your Social Security the month of passing. Also, if there is a married couple and the higher earner of the spouses passes first, the surviving spouse gets to keep one Social Security, but the higher Social Security amount.
to know so much information. And I'd like to direct this to the whole panel. How should people go about finding reputable professional resources, lawyers and financial advisors or planners? I know there's a lot of information out there, but we'd like to learn from you. Where should they go?
So I know Roberta shared this and I agree. So the Westchester County Bar Association, which is our local bar association, or your local New Rochelle, White Plains, Yonkers, Mount Vernon, you can always call for a referral there. I actually think it's really good to speak with your financial advisor and or accountant as well, because they probably have a relationship with an attorney and with attorneys with financial advisors. Again, because you want a trusted professional. A lot of times I'll get referrals from a client of mine gives my name to somebody else who then gives their name to somebody else. But it's always, I would do homework too, right? Check online, look at a person's website, see if how they're involved, how long they've been practicing, if there are any designations, right? You can have a professional, accreditation, and see what their involvement is. And it's always have a consultation first, because, right, Sally, you and I might get along, but Isaac, you might meet with me and like, oh, I could not stand her. You have to make sure you're comfortable with the financial advisor, with the attorney, because if you're not comfortable and it's not a good fit, it won't be a productive relationship. And it's okay to meet with one or two or three, though I think that can just get time consuming, attorneys, financial managers, to really make sure that person is listening to you and addresses your needs. Right? Because I can meet with Isaac, Sally, and Roberta, and you'd all think it'd all be the same plan, but it's not. you don't want cookie cutter. You want to really be heard. And what are your goals and expectations? And again, make sure it's that important fit. I also, the same way, like, don't come to me if you have, if you're in a criminal matter. I like to use somebody, because I don't practice criminal law. So I wouldn't use a criminal attorney, though they're very good, to do your estate planning or your Medicaid planning, because again, you want to make sure it's a person who has expertise in the area. And I'm not begrudging criminal law attorneys too. I think we need them. I'm just not qualified. I went to law school, but you don't want to call me if something happens in that respect.
Right,
If
and
I may,
love
I'd love
what
to
you
share a
said.
story, Sarah. Oh, sorry, Sally, after you, please.
I love what you said about what the expectations are. Some people may want to talk to their lawyer, their financial advisor, or their financial planner very often. But it's also developing the relationship. It's also who you feel comfortable with. Isaac, go ahead.
Oh, so I was going to share a rather funny story. So a client of mine who also is an attorney had another attorney draft his will, but the attorney that drafted his will was more involved in naval matters than he was in anything else. And when I read the will, it sounded more like he was a boat than he was a person. And so it's really important that you have the right attorney. I absolutely agree with Sarah. And to further that, I would say that whomever you're interviewing for the role of attorney or the role of financial planner or advisor, if that person is not asking really great questions and getting to the heart of what's most important to you, then that person probably isn't going to be the right fit for estate planning. They might be a great wealth manager, they might be a great attorney, but when it comes to estate planning matters, the details truly matter. And so you really want it to feel like you're going to the doctor for the very first time and they're poking and they're prodding and they're finding out what hurts. And if not, it's probably, again, not the right fit for you. Unless you have a very plain vanilla situation. And I haven't met anyone who's been plain vanilla in the 16 years I've been practicing as a financial planner. So that would be my opinion. The only other thing that I would say is, again, going back to my very first question, really interview the expertise of the financial planner that you choose to work with. If you do have a more complicated situation, as in you have multi-generational families, so you've been married and divorced several times, you have business, you are an owner of a business or in several businesses, you've got lots of real estate. These are nuanced things that not every estate planner, every financial advisor is comfortable dealing with. And so find a specific team that is very understanding of what you are dealing with.
I would just like to throw in one other piece of advice, and that is, I mean, it's certainly okay to ask family members for referrals for financial planners and attorneys, but your consultation, you should be in that room by yourself so that you are not influenced by anyone else's interests. And if after your initial consultation, you're comfortable and the professional understands what it is that you want to do, if at that point you want to bring this other family member or other family members into the consultation, then that would be appropriate, but not initially.
So, and I just want to, if I may tag on for 1 second to what Roberta's saying, going back to Sally, you asked a question about will contests, right? So Roberta, Isaac, and I are siblings. I take mom to my lawyer. I sit in, the attorney talks to me about mom's wishes, right? No, I should be sitting outside. Mom should speak to her own attorney. I should not be involved in the process. You want, just to speak to your client and take direction from your client. So I actually, we in our office, when the whole family comes, we actually ask the family, after we sort of do big introductions on what estate planning is and the importance, when we start talking about details, we have everybody leave the room.
Great tip, just that alone. So we have another 30 minutes to go for our webinar, and we have 24 questions from what I understand from Ginny, who's also on our fee committee. There are some questions that were answered, so I'm going to turn it over to Ginny, and Lana is with her as well, to see what questions we have left to ask. There are a ton of questions, we love it. So let me go over to Ginny. and ask her to start her video and unmute so that I can pin her or actually make her okay, I will
Okay.
add the spotlight. Okay.
Fine, thank you. So some of the questions have been answered, but I think in all fairness to our participants, we'll just review those questions as well. The first question came from Colleen, and it was, having some technical problems here. Does an additional owner's name have to be on the deed trump the will that gives the house to someone else?
So yes, so as we talked about earlier, if Roberta and I own a house jointly, so it's owned by Sarah Myers and Roberta Goodman, joint with right of survivorships. If I pass first, the house is owned by Roberta.
Excellent. One from Hope's Door. What is a living revocable will trust, rather? I hope I pronounced that right. What is a living revocable trust?
Okay. Roberta, do you want me to do that or do you want to do that?
You can take it.
So a revocable trust is a document a trust that I can create in my lifetime. So it'd be the Sarah Myers Revocable Trust or Revocable Living Trust. I can then be the trustee of that trust, as Roberta was talking about earlier, and I can title my assets to the trust. So Isaac is my financial advisor. I can retitle my brokerage account that Isaac oversees to the Sarah, it should be owned instead of by Sarah Myers to the Sarah Myers Revocable Trust. I can do a deed of my house to the Sarah Myers Revocable Trust. What does that enable upon first in my lifetime, I maintain control. And like a will, a trust names beneficiaries. What is the advantage of a revocable trust is upon my passing, the assets that are owned by the trust, that brokerage account that I retitled to the name of my trust, my house, which is now owned by my trust, pass to the beneficiaries named in the trust, with avoiding probate, without having to file a petition with the court to have the will admitted to probate. You might still need to do that, as Roberta said earlier, because you might have forgotten to title an asset to a trust. But a revocable trust is really used for ease of management and then also for privacy purposes, because upon my death, if a will is admitted to probate, the surrogate court files are searchable. I can go to the surrogate's court and look for the name of a decedent in their estate and read their will and whatnot. So the revocable trust affords privacy, but really ease of management in my lifetime and upon my passing.
And I think if there's property outside of New York
Yes.
and you're a New York resident, it facilitates the distribution of that property upon the death of the creator of the trust, because you don't have to go into a court in order to have that disposition happen, because the trust
For
document.
wealth management purposes, it helps a great deal as well. I agree.
And I just forgot to add, because we didn't really talk about Medicaid here, this was not really the right forum, but for Medicaid, if my house is owned by a revocable trust and I was on Medicaid, the property in the revocable trust avoids probate and therefore avoids Medicaid estate recovery. So Medicaid can't put a lien on that property upon my passing.
Excellent. And I hope what you said answers the next question, which we got from Westchester Library System. What is a trust and what are they used for? The next question is from Linda Jones, and it's, please ask Sarah to reiterate that accounts with listed beneficiaries, for example, bank accounts, retirement plans, like a 401k, are examples of assets outside of the will. So it is important to review your list of beneficiaries each year to make sure the beneficiary list is up to date. I've administered accounts where the surprise of the current spouse, the ex-spouse, was listed as the beneficiary.
Ginny, I think the question or statement was stated well. I think we think that we're good there. So thank you for the person who put the comment in the chat.
Excellent.
I would like to go back to Colleen's question, make sure that we answered it. She said, I want to know if someone is named on the deed for the house, but the will designates someone else to receive the house. Does the person on the deed get the house or the person named on the will?
So
On the
yes,
deed?
is, oh, Roberta, please.
It's on the deed. As Sarah said, it's by operation of law. So depending upon how the deed is titled, who are the owners? If the joint owner is still alive, then that property will pass in full, if it's a joint with right of survivorship, to the other joint owner if they're alive. If, however, the joint owner has predeceased and no deed retitling has been done, and that property is not in a trust, then that property is going to go through the probate process and to the person who's named in the will. It could very well be the same person. It could be the named joint owner, and the person in the will is the same as that joint owner. If they've predeceased, then the will govern who inherits. If the named beneficiary in the will predeceases the testator, the decedent.
Okay, I'll go on to the next one. This is Hope's Door. For power of attorney, is it recommended to renew it? Just a question mark after that. Beneficiary list is up to date. I've administered accounts where, to the surprise of the current spouse, the ex-spouse was listed as the beneficiary.
So
So
if
yeah.
if your named agent is no longer capable of being your named agent, if the law has changed significantly, then it would be appropriate to update your power of attorney, as long as you have the capacity to do it. Now, there's a little wrinkle here, and we're getting into the weeds, but let's just say you have an existing power of attorney and you shared that document with your bank. And now the person who you named as your financial agent you no longer want that person to be your agent, because they've maybe mishandled your estate, or they're incapable themselves of managing your money, or there could be a multitude of reasons. So you need to do a revocation of that power of attorney. You need to send notice to the financial institutions that you've provided with the power of attorney, and also to the person who's the named agent. Provided that they're alive, you have to put them on notice that they no longer have the right to act as your agent. And then, provided that you have the capacity, you can do that, and then you should do an up-to-date power of attorney. I want to just point out a practical matter. Let's say you did a power of attorney 10 years ago and the law hasn't changed. The law has changed in the past 10 years, but let's make believe it hadn't changed. And your agent is still the person you want to be your agent, but you've never presented the document to a financial institution, a bank, brokerage house, whatever. And now you present this 10-year-old document, and the person who's sitting at the desk who's receiving it is looking and saying, the agent, how do I know that you're still the agent? How do I know that the principal still wants you to serve? So if you have a really old document, and all things being equal, you should update it.
Okay, excellent. The next question is from Ida Serrano. Is advanced health directive same as healthcare proxy?
Yes.
It's a category, but yes.
Okay, excellent. Colleen has another question. Can you place a home in a trust if you still have a mortgage on it?
So the answer is it depends. You have to speak with the bank, the lender, to see if they'll allow it. Usually a revocable trust, yes, because the asset is still yours. Usually an irrevocable trust or a Medicaid asset protection trust, no, because technically the home is no longer yours. So you really have to speak with your lender and with the bank to see what they will allow.
Another question from Colleen. When is the best time to start planning for Medicaid coverage if you don't have insurance to cover nursing home or home care? I understand there is a 5-year look back. What if you are healthy now?
So it depends on a person's age, like and how they're doing and if they have long-term care insurance and if they want to start protecting assets for the cost of long-term care. There's not the same answer for each person. It's a very personal choice because if you're going to be doing Medicaid planning, you could still live in your house if you're putting the house into the trust, but in terms of your brokerage account, your cash, you no longer have control over it. It's being held by the trust. So there's a 5-year look back for nursing home Medicaid. So if I transfer assets into a Medicaid asset protection trust, January of 2024, that transfer will preclude me from being eligible for Medicaid to pay for my nursing home care until January 2029 for those 5 years. There is right now, no look back period for home care Medicaid. So if I put all my assets in a trust today, next month, I could be eligible for Medicaid, if I meet the requirements, and then for Medicaid to pay for my home care. So again, Medicaid planning usually is done when someone is still healthy to be able to then protect those assets and not need care for at least 5 years.
Next question, Giselle Ayala. Can you place a condo in a trust?
Yeah, again, if there's no mortgage on it, we're going to take the mortgage aside. A condo is like a house, it's real property, and you could do a deed transferring your condo into your trust.
Excellent. These are great questions. Martha Anderson from Westchester County Office for Women. What are the fees for these services?
So I'm going to assume the question is, what are the fees for the legal services? And I'm going to answer with an answer no one's going to like, which really is depends. Because
Right.
each person's needs are different, right? Sally's needs might be different from Ginny's needs, that might be different from Lana's needs. So it's not a question that we can answer, more that there's usually a range of charges depending on the work that's going to be done.
I would agree for financial planning as well. Jenny, some financial planners will charge a flat fee.
Mhm.
Others will charge a percentage of assets that they manage. It really depends on the model that the attorney or financial advisor is offering.
Okay. Sally, I think it would be appropriate after our Q&A if I list our resources. Is that okay with you?
We can actually have Juliet put the resources in the chat. Juliet can do that for everyone, so that way they can write it down. We know we have a time limit of 1:30, and we do have a
Right.
survey that we want everyone to fill out, like about
Right.
1:25. So we have 10 minutes, but I think we can get through these questions, and they're really great questions. We really appreciate them. Thank you, Ginny and Lana, for taking care.
Excellent. This is from Kate Permut. This has helped me realize there are so many laws in New York that apply to me, and I was not aware of it. So I think that's a good shout out for this webinar. Thanks, Kate. Ida Serrano, can you place co-op in trust?
So co-ops are shares of stock. They're not real property, and the shares of stock are governed by a corporation. So co-ops have management companies and they also have counsel. Each co-op has different rules. You have to find out from your co-op whether or not they allow the transfer of the shares into a revocable or irrevocable trust.
Colleen has another question. How are estate taxes determined?
So there's both a New York and a federal estate tax. The federal estate tax is about 13 million for this year. The New York estate tax is about 7 million for this year. So if you pass away and you have 14 million in assets and it's not all going to a spouse, you will have both a New York and federal estate tax. If you have 8 million in assets upon your passing, and we're talking about in New York, you will have no federal estate tax, but you could have a New York estate tax. And it's, in short, it's calculated by what your gross estate is, gross assets are, less a number of deductions. And if Isaac wants to get more granular, I'm very happy for him to do that.
Sure, Sarah. One of the things that's important for everyone to understand, however, is that if you do have assets in an irrevocable trust, those assets are no longer considered part of your estate in most cases, in which case that would not be something that would be included in that total number. Now, there is also the opportunity to benefit from a spouse who passed away. You have the benefit of being able to utilize part of their exemption as well. So there is that element for the federal where you can benefit from a spouse passing away, utilizing theirs or sort of cannibalizing theirs for the future. So that is something to consider as well.
That's why it's an important thing to consult with an attorney so that you have this planning done. You can do it in your will and you can also do it post-mortem, but there is a limited time within which to do this kind of planning, and that time is 9 months from the date of death of the first spouse to die.
And I've had clients, unfortunately, at the deadline scrambling to get those documents in so that they have the benefit of taking advantage of that opportunity.
Just in terms of portability, if you're electing portability, if you're filing an estate tax return solely to elect portability, it was extended last year to now you have 3 years to elect portability. If
That's
it's
only federal.
federal, New York State has no portability.
Mm-hmm.
Julian Armstrong, another member of our feed team, is offering 2 questions from our Crestwood participants. The first one is a trust better than a will?
Depends.
Okay. It depends what a person's, right? We talk about nobody's cookie cutter. It depends on what the goal of your planning is.
The second question is, do you need an executor for a trust?
So an executor for a trust is known as a trustee.
Okay, so the answer to that question is yes.
Right. So when you have a trust, if it's a revocable trust, you can be your own trustee, but then you should always have a successor trustee to act if you become incapacitated or upon your passing.
And Sally, my last question is, in estate planning, who do you use first? A financial planner, a state's attorney, etc.?
Both.
Yeah, I would say the coordination is key. There are planners like myself who have a sophisticated team around them and can have the support of an attorney on the team, a CFP, a CFA, but not all financial planners do. So I think the key feature would be finding the person that you are comfortable coordinating the entire estate planning team.
I do see another couple of questions.
Yeah.
Another question from the Crestwood audience. If you own a house and you leave it to someone and you still have a mortgage, will that person have to pay off that loan? Can they take over your loan?
So what happens is this: if the house is in the decedent's name alone, so house is in my name, I leave it to Roberta. It's in my will, it goes to Roberta. There's still a mortgage. The executor of the will cannot deed the house when deeding the house over to Roberta, if there are other assets in the estate that can pay off the mortgage, great. If not, the house will have to be sold to to pay off the mortgage. Or Roberta can't assume my mortgage. She would have to do a refinance and take out a mortgage, which would also pay the bank back for the outstanding mortgage, and then she would have her own mortgage.
And some of those older mortgages still have a term in the document titled callable at death, which is an important feature. So you do want to be very careful about the mortgage that you have. And if you happen to be older and buying a property, that is something that I would urge everyone to be very careful and review. It just means that mortgage would have to be payable within a very short period of time after the passing of the owner of the home.
Okay, well, these are all very good points. Wow. If you have power of attorney for your parents, are you automatically their healthcare proxy?
No.
No.
Question? No. All right. Juliet did put legal referrals. The Westchester County Bar Association has an attorney referral program. She put the number there, 914-761-5151, as well as a website, wcbany.org. She also put financial referrals. Folks can get a list of financial professionals and their background by visiting brokercheck.finra.org. And then let's see. Oh, Colleen has slipped another question here. Are you saying if assets are less than 8 million, you do not pay estate tax?
So the New York estate tax for 2024 is 6.94 million. The federal is about 13.1. So again, 8 million I just used as an example when we were discussing the New York and federal estate tax. The New York estate tax is 6.9, federal about 13.1. If your estate is hovering anywhere near the New York and/or federal estate tax, I recommend you speak with an attorney, a financial planner, and an accountant regarding your particular estate tax planning needs.
And I know we have a few nonprofits, obviously WWA, and some of the clients, like you said, everyone should have their documents together. Some of the clients won't be able to, go to lawyers or have access to lawyers. So Juliet did place in the chat for the folks who do not have family or friends who have access to financial professionals. One of our community members mentioned the Family Planning Association of Greater Hudson Valley, which has a pro bono program that offers services to people who belong to underserved and/or high-risk communities at the following link, www.fpaghv.org. And I believe that is the end of our questions. I would want to, once again, Juliet is going to put a survey in the chat. Please do not leave our webinar. Please do complete that survey. For us to improve not only the community programs and what we offer in the future. This is just January, so we have a whole year to offer. And we once again want to thank Sarah Myers, Isaac Cohen, and Roberta Goodman, the FEE team. Ginny, thank you so much for taking charge of those questions at the end. I'm so glad we got through them, and we still have time on the clock. Lana, thank you there for being backup as well, and Juliet for posting, and Lisa for also being with the Westchester Library System. Again, thank you to the Westchester Library System. Do get your library cards, bunch of resources there as well, and learning, if you want to talk to somebody, obviously, but if you want to learn more about it for yourself and on your own time, use your local library. It's a fabulous resource. And there's the Survey Monkey. Thank you, Julia, for putting it on there. Any final words, Sarah?
I was just going to say, Sally, no one thanked you and your team from the Westchester Women's Agenda, the Women's Economic Empowerment Group, for really putting together this great panel. And thank you for giving me and us the opportunity to share some of our knowledge and with the people participating today. But Sally, couldn't have been done without you and your team. So thank you.
I echo that. Yes,
Sally.
thank you so much. And I would just offer, if there are any other questions that come to light, if it's appropriate and you want to circulate it to one of us, we could respond.
Absolutely. And we can definitely, thank you, Colleen. Thanks to the speakers and the FEE team. If you have a website that the folks can visit, please put it on the chat. That'd be great. Isaac.
So I want to echo everyone's thanks for putting this together, Sally. Thank you to the team for supporting this. This was a lot of fun. I don't usually have a great format like this often. I'm finding people are doing this at the last minute. So it's been a pleasure. And I'll be putting my website in the chat in just a moment.
Thank you. And again, we have a lot of resources. There are a lot of resources out there. Please take your notes, mull over them. But the best thing you can do is to take action. Take action on everything that you've heard. If you have family members who could have used this information, we do have a recording. We'll get it out to the participants, or we'll figure out a way of publicizing this webinar. And we thank again all our speakers, WWA and the FEE team. WLS, the Yonkers Public Library Crestwood branch, before I forget again, the National Council of Negro Women, Hope Store was there as well, West Tab, all you guys, you just splendid. And I think that's it. We'll stay on for a few more minutes just in case we need people need to finish off the survey. And that's a wrap. Thank you, everyone.
Thank you.
Bye, everyone.
Bye.
Juliet, let me know. We still have folks on, so I won't end it until, just in case they're trying to grab the survey.